Trying 5 accused September 11 suspects in New York City could create a big liability for the CIA, some say, bringing controversial Bush-era interrogation practices back into the spotlight. Michael Isokoff is an MSNBC contributor and investigative reporter for Newsweek. He writes about the CIA complication on his blog, Declassified. Michael, great to see you. Thanks for joining us. Let's talk about Declassified today. Well, what do you think are the problems for the CIA potentially with these defendants, particularly Khalid Sheikh Mohammed, going on trial in New York City?
Right. This issue of interrogations and the CIA's use of enhanced interrogation techniques, waterboarding and other techniques against Khalid Sheikh Mohammed was one of the big issues that Eric Holder's team confronted when they were whether to proceed with this a civilian trial of the 9/11 conspirators, because inevitably in these sorts of cases, defense lawyers are going to try to gain as much information as possible, evidence as possible, to raise questions about allegations of torture against their clients, and that's something that's been steady in any trial of this kind. And in this case, with Khalid Sheikh Mohammed, a guy who was waterboarded 183 times, it was front and center. So what the Justice Department tried to do here was craft a case that's essentially torture-free, that relies on evidence completely independent of the aggressive interrogation techniques that were used against these defendants. And that includes excluding a lot of statements that they made after they were subjected to these techniques, but it's still going to be very tricky to see whether federal judges are going to go along with that and whether they're going to be able to keep that evidence out.
In your blog, in Declassified, you write, even if justice can carve out a torture-free case, defense lawyers are expected to find creative ways to introduce evidence about abusive treatment, challenging the origins of every document and seeking access to CIA officers who question the detainees. The defense could have greater latitude to bring up torture allegations in proceedings to assess the defendant's mental competence, and later on during a possible sentencing phase when, quote, mitigating factors can be raised in death penalty cases. That said, Eric Holder is pretty confident, and you just heard Michael Chertoff, and he's gone over a lot of this evidence when he was dealing with Moussaoui. They're pretty confident that they have an ironclad case against Khalid Sheikh Mohammed. And why shouldn't we show the world that we can put them on trial, that the U.S. system of justice is beyond reproach? It's the, the gold standard for the world.
Right. Right. I think that's the argument that ultimately swayed Eric Holder to go ahead and proceed with the trial. But that said, I agree that I think they are fairly confident, very confident, that they can get a conviction in this trial. But I don't think they're quite as confident that they could keep out some of this evidence in the very matters that I raised in the declassified item. Mental competency. Ramzi bin al-Shib's mental competency was being adjudicated before the military commissions. There were questions about whether he had been sedated and given so many drugs that he has been irreparably harmed. That's going to be a big issue in the civilian trial, and that leads inevitably to how he was treated in CIA custody. Similarly, in the death penalty phase, almost anything could get introduced by defense lawyers as a mitigating factor. So it's going to be a struggle to keep the evidence of the CIA's aggressive interrogation techniques out of this case entirely.
Michael Isokoff, thank you so much. And log on to blog.newsweek.com for Michael's latest postings on his new blog, Declassified.